Um,
Hello? Hello?
Yes,
yes,
Okay, so the child is now living with the father.
that is correct.
All
correct.
right, and we're going to stop the child support, and that's the request of the parties.
Yes, it is.
That's correct.
Okay. All right, no problem. Yeah, you can generally do that at the front of the court, but they ask you to come to court to make sure that we get a good order to say so.
Yep.
It happens a lot. You know, kids choose to sometimes switch places, and they'll switch back, and they'll switch back and forth. Teenagers, welcome. What, 13 now?
He's
14?
gonna be 13 in August.
Yeah, yeah. It's the beginning. Good luck to both of you.
Thank you.
But my comment is always raising a teenager is trying to like nail Jello to a wall. Good luck. But we will get you a support order that says it at 0. All righty.
Oh, thank you. I guess we're also wondering where the payments have been going.
I have no
That
idea.
oh
I have no idea. That was going to be I wasn't going to bring it up, but because this is such an old case, is state aid still involved?
we're not sure.
Because what's going to happen is they will automatically send this back for a review to set child support at a level. Because if state aid's involved, I suggest you get with DHHS and make sure that it gets canceled if it's not canceled. Because I can stay out of your life and set this at 0 as long as state aid's not involved. Okay. I'm assuming that
Okay.
the kid changed roofs, the state aid generally goes to one house, not the other. So when he changed houses, normally that's what happens is the state aid stops. But confirm that, and then it'll set at 0 and stay at 0. Because again, I'll stay out of your life as long as the state's not involved. Okay.
Okay.
I don't know where the money's going. Well, how long has it been since you've seen any child support?
Um, Olavo has been paying child support, and still is. I haven't
Correct.
received anything since November.
Okay. Olevo, did you notify the front of the court the child was living with you?
Not yet.
Okay, then that's weird because normally sometimes what happens is when the child moves, the parent notifies the front of the court. The front of the court withholds the money to be
Mm-hmm.
released back to the other person. But if
Oh,
you didn't tell them, I don't understand where the money's going.
okay. So
You might want to check with them because
okay,
none of that is in the court file. That's because the court file is public document.
okay,
So you don't want a lot of your information about your child support, your employer, and
right,
social security numbers being in public documents. So
right.
a lot of that, including the arrears, the court doesn't know until the front of the court notifies us that there is an arrearage or that there's an overpayment or an underpayment. So you might want to check with your front of the court worker. Okay.
Alrighty.
All right. Take care, and I'll get this set at 0 as of probably April 1st. All right.
Okay. I have one more question. So,
Sure.
I need some paperwork to send to my HR. That way they can like stop doing the payments.
That's what the front of the court will automatically issue that.
Oh, they're gonna issue that.
Yeah, there's an income withholding order that again does not go in the court file,
Okay.
but that's why they tell you, if they'll hold it for you when you notify them of the address change. But
Okay.
they have you come to court to officially change and stop the support. That way they can issue a proper income withholding order that deletes the old one.
Okay.
And that'll be the process. Okay?
Already.
All right, good luck. Take care, both of you.
You too.
Thank
Bye
you.
bye.
Oh, no, 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 don't fall. No, no, no. Okay. Caught it. All righty. Okay, Miss Burns, did you connect?
I believe so. Can you hear me okay?
Yeah, yeah. Mr. Burns, you connected?
I believe so. Can you hear me okay?
Yeah, yeah. Welcome to both of you. We're here in the matter Burns versus Burns. Ma'am, you've attached a listing of all of the medical that you're requesting, correct?
That's correct.
Was this all of it?
That's all the over a year unpaid stuff. Correct.
Okay. The reason that I'm asking is because according to your numbers and I noticed the judge granted this to be reviewed, and something has happened with all those reviews. So you're stuck in this position. But my math shows that in 2020, you're asking for $206 worth. 2021, it's $37. 2022, it's $162. 2023, it's $1,488.99. and 2024 is $2,639.56. Is that correct?
I had it totaled to be
No,
like,
I got to do it year by year, and
okay,
there's a reason, and I'll explain that.
yeah, no,
Okay.
that's okay. I can
Yeah.
total them individually currently if that would be
Okay.
helpful.
Well, I did that. That's why I'm asking if my numbers sound okay, because here's how this works. You've seen the child support order that was entered, correct?
That's correct.
All right. In there is an ordinary medical expense.
Correct.
That's a $908. Okay.
Correct.
That he pays his portion of up front. Okay.
Correct.
So you have to hit $908 before you get reimbursement.
I understand that.
Okay. So in 2020, you only hit 206, and that doesn't even come close to 908.
No, I've already submitted everything that all the medical expenses to friend of the court and was paid for them. These are ones that were outstanding over a year. So typically I will submit them to friend of the court.
Yeah.
They have him pay them. And then in they're over a year, I have to file a motion. So for example, currently he
So,
still owes me just over $1,000 from the last stuff I submitted to friend of the court. That is something that they will facilitate without a motion
right. They normally facilitate this, so I'm trying to figure out why this is extraneous.
because it's over a year. So they will only facilitate dates under a year.
Because I don't have the proof of the 908 that's already been accomplished.
So historically, because this is not the first time this has happened, what they
Right.
request is simply that you issue a request that friend of the court review
Which I
it.
did, and neither one of you cooperated with.
Can you explain further?
But yeah, the front of the court terminated the review this was sent to by the judge
Can I
because
explain why?
neither one of you cooperated with it.
That's not correct. I paid the amount.
Okay.
The other party failed to pay the amount. So we received notification that it had been canceled because
John,
the other party
why didn't
didn't
you
pay.
pay your amount?
Um,
Because this would have all been taken care of because that's what this was sent for.
I understand. I believe that I had paid my amount when we were in court last time. We agreed on a number and I paid it that day to Miss Burns.
Paid what? Wait, are we talking about the
I-
medical expense or the front of the court expense?
The medical expense.
What did you
Which-
pay her?
I don't have those facts in front of me. I mean,
Really? I mean,
Yeah.
that's why we're here. Did you pay it by check?
yeah, this was like a year ago. Listen, I'm willing to pay whatever is necessary. It's just I don't know what is necessary at this point.
Well, if I added all this up, well, I did it year by year because since I didn't have the underlying 900, I had no choice.
The total
Um,
is just under 3,000.
Let's see. Well, let me get my calculator. I'll be right back. Okay, I had it over there because I did this math last night. So the total is $2,533.55. Your portion is 64%, sir. So the total would be 1,621.
I have a different total unless I added it up.
What's your total?
$2,969.55.
Okay, what am I missing?
There should have been 4 pages of expensive.
Yeah, there were.
Okay.
That's how I got the numbers for each individual year.
I could have added, I did it before the Zoom
Well,
call quickly, so.
Actually, I think I only have, no, I do have 4 pages. I'd rather spend a couple extra minutes this morning than to have to give you guys a hearing and take off work again. And is the child no longer in speech therapy, or is he still in speech? The child's in speech therapy still.
He still is. And this is my frustration, Your Honor, is that I pay out of pocket,
Right.
$100 a week, and I've repeatedly asked him to help, and I have multiple proof texts of me requesting him to pay his payment, and unfortunately, I have to continue to burden the court because
Do you send him the bills, copies
I
of the bills?
do. Yep. These ones over a year, there was different issues with correct receipts, friends of the court. And to be completely transparent, it gets frustrating having to do it this way, and it takes forever. And so sometimes I am late, with friend of the court, and that's where I have this extensive list.
All right, what was your number, ma'am?
$2,969.55.
Yep. All right, 2,900. That was okay. That's what I got. So that would be $1,893, sir. Have you talked to the providers? Some providers, if you give them a copy of your judgment, they will automatically bill out the appropriate portion.
Hmm.
You can ask the provider, and then John would get his own bill, and then he would know what he had to pay.
Sure. Historically, in the past, if the bill wasn't paid, then my child wouldn't receive services.
Right. Well, and again, you have to hit the $908 first for the year.
Yeah.
So that's the other problem. And then it's done year by year. That's why I broke it down by year.
Yeah.
Okay. What are your questions, sir? Because you said you're willing to pay it. That's why I went on.
Yeah, I am willing to pay it. I don't have the money to pay it right now, so there has to be some sort of way we can do payments or something. I mean, I don't have $1,800 laying around to just hand over.
Yeah, normally, well, she's got to come up with this up front. So, and this is after insurance. What I normally do is I can't add it to the arrearage, which means the front of the court will automatically collect it for you, Ms. Burns.
Historically, they like the current stuff, like what he currently owes me is
Right.
is over $1,000, and they
Right.
can only add it to be $25 a month, is my understanding. But stuff
Yeah.
over a year, my understanding is it can be more than that.
They're not allowed to touch stuff over a year, but I can put it in the arrearage, and that way it's a collectible and it stays there. That way they'll keep track of it. So I'll put the $1,893 into the arrearage, and that way they collect it over time.
Okay.
right.
My last remaining question is, because I've had to continue to file motions for this. This is now the second time I've had to pay motion fees out of pocket because
Right.
he was, I was the one who paid the friend of the court. I followed all of the rules. He failed to do that. They issued a appeal. He didn't do that. And so then the evidentiary hearing was canceled because he didn't pay. I continue to be the one who's impacted by this, and then I have to
Right.
file the motion fees.
I understand.
Is there a way that I can also be reimbursed my
That's
motion fees?
unfortunately, that's the process for now.
Okay.
All
Your
right.
Honor, I have a question.
Yes.
So this speech therapy thing, I mean, obviously I care for my son's well-being and his health, and that's obviously my top priority. I have talked to Ms. Burns several different times as this speech therapy is no longer necessary. I mean, he's very advanced. And
Well, why then you need to talk to the speech therapist.
okay.
I mean, bottom line, each of you have the right to contact any and be involved with any provider that's providing services for your child. Schools, doctors, dentists, all of it. But that information is a discussion between you and that person. And then they can explain to you why they believe it's still necessary. Because they have to bill it under insurance, which means they have to kind of make sure that the treatment is necessary. You don't just keep going on something that's no longer necessary. So while your opinion may be that he no longer needs it, then you need to talk to the person that's actually doing the therapy to make sure that you understand why it's required or when there is a timeline to, because it might just be maintenance stuff too, as a speech therapist. Who knows?
And Your Honor,
Yeah.
recently my son had an IEP review plan, and his
Okay.
father wasn't even present for that, so he
Yeah.
can't,
Sir,
state
you
that
got to step up the game here, man. You said you want to be a father, then you need to be a father. Get to the IEPs. Ma'am, when you send him the receipts, sir, review the receipts. Once she hits that 908, you can calculate the 64% yourself. But you need to be involved with the schools. You need to be involved with the doctors. You just can't sit back and go on autopilot. That's not being a father. So get your butt in the game, okay? Go talk to the speech therapist, find out if it is necessary. And this shouldn't be necessary either. Sir, the two of you should be able to work this out. This is your child. Take care of it. The orders are what the orders are, all right? And she's right. She shouldn't have to come to court all this time. Because insurance companies can have a lag time of 6 months or more in trying to pay off the debts. So sometimes you don't know what the uninsured is for months. So take care, ma'am. I'll get this order for you and we'll get the money so that it's at least preserved. So that takes care of everything from 2020 through 2024.
Thank you, sir.
Sir, Be
Can you
involved with
further?
it. Yeah.
I
Yeah.
am actually very involved. But at the
Well,
same time, so
have you
what is?
talked, when was the last time you talked to the speech therapist?
It's been a few months.
Okay,
Do you
then.
know who his
Yeah.
speech therapist is?
I'm not getting into this all right now. What does the $1,800 mean for me, and how do I make sure that it's being paid properly?
It's going to be part of the income withholding order. That's why I'm doing it, because it's automatically going to be paid. And it'll be
Understand that, but
reserved, which means
does that mean a certain dollar amount per
yeah,
paycheck?
it'll probably increase by the paycheck.
Okay.
All righty.
Yep.
Okay.
Thank you,
Good.
sir.
Good. Well, good luck.
Thank
Have
you.
a good morning, everybody. Who do we want to do next?
Next, we can do Conley versus Haveman.
Oh, Lord. Okay. My notes are all over the board on this one. Miss Ballast, Mr. Vandenheuvel, welcome.
Thank you.
All right. I'm going to start with the odd statement in the pleadings. Well, let's go on the record of the matter of Conley versus Haveman, because this one kind of threw me. What do you mean, Miss Ballast, that technically the parties are not married? This is a divorce case.
Correct. There were proofs taken on the record
Yeah.
earlier this year, and then we
Okay.
filed a motion to set aside a default and a default judgment of divorce.
So the default judgment of divorce is still in or out? I thought it was dismissed.
It was dismissed, so there was never, proofs were preserved, but that doesn't mean that you're divorced.
They're not divorced. They're not divorced. There's no technically about that. The
Okay.
parties are not divorced until the judgment goes in. Okay, that explains. I was trying to get. I'm like,
It is a little unusual.
I've seen weirder things happen, but no. Judgment has to be entered to make the final divorce. They can't get remarried to anybody. Hopefully, nobody has done that, right?
I'm sure they haven't.
Okay, good. Yeah. Well, I don't know. I had somebody admit a few weeks ago to they don't understand why the divorce is taking so long. They got remarried 3 weeks ago. So I just my jaw dropped. But anyway, so it does.
We had a file together that recently got dismissed. There was a Florida marriage and here.
Okay.
I think it was on your docket. And anyway, they
Like I said, I've seen weird things happen.
Divorce.
Yeah, I've seen weird things happen. So in any event, so they're still married. The gist of this is how much medical expenses have been incurred since the insurance was dropped.
I'll let my client speak to that. Renee?
Ma'am, how much medical expenses have been incurred?
Well, I've actually been advised not to go unless I want to pay out of pocket.
Again, that's not the answer to my question. I want to know what's been incurred. Have
I
there
have
been
not-
expenses?
No, I have not been
Okay.
to a doctor.
So technically, the only damage is you have not been able to get to a doctor.
Correct.
Okay. Because I'm asking these questions for a specific reason. Because right now, at this point, I'm just trying to get you guys through this.
Thank you.
Because Miss Ballast, your client, I'm trying to figure out how he deleted her from the insurance outside of the enrollment period. Because he deleted her before
I don't think there was
October.
ever an intention to delete her.
Well, he dropped her from the insurance.
He was fired from a job after an earlier
But
motion in
he was
matter.
fired long after he took her off the insurance, according to the pleadings.
No, that's not true. There was an earlier motion in October of 2024, and my client was fired 2 days after the order to reinstate was entered.
Okay. And you're saying that there was some fraud in that, Mr. Vandenheuvel, correct?
Correct. When we filed, actually, he was not fired. We knew about him taking her off.
Okay. But he took her off beforehand, and I'm still trying to
Correct.
figure out how he did that, because you really can't do that without an event unless you're in the enrollment or disenrollment.
It was never an intention to remove her from insurance.
Oh, you have to intentionally remove somebody from insurance.
He
Ms.
lost
Ballas.
his job.
You don't no, the insurance was dropped before the job was lost. Like
If you'd
months.
like to inquire of my client, I can have him be present. I see that he's not.
When do we know that the insurance was dropped?
So my boss canceled the insurance. I'd never told him to.
When did he cancel the insurance?
It was while I was still employed. I was fired when I brought the motion to him or showed the motion to him to reinstate insurance. That
Okay,
is when I was
so
fired.
can you give me the timelines, please? Because I asked a specific question. When did he drop her from the insurance?
I do not have that date.
Seriously. And you were fired in October.
Yes, it was probably 2, 3 weeks before I was fired there.
And why would he have dropped her from the insurance?
Because what he says, he was sick of paying for it when we were not together anymore.
How long were you separated? You were separated a few months by that point in time, correct?
It was almost 6 to 8 months.
Okay. Yeah, he doesn't really get that choice. So, it sounds like, Miss Ballast, you might have some other legal work to do for your client. Uh, but now we're at the stage that we need to get her insurance, and the question is, what's the better way to do that? Put her on his insurance at his new place, which he doesn't get according to the pleadings until May, because he's got to be
Correct.
there long enough. Ma'am, and you work for Horwell Health, correct?
Correct.
And when are you eligible for insurance? Because you're going to have to get your own shortly anyway.
Correct.
So,
Once I'm divorced, I honestly didn't know that it would take this long. I thought once the default judgment went through,
well, once the default judgment was placed in, it should have been done, but it was overturned. So we're
correct.
back to square one. So you're right. It's taking longer than everyone thought. But my thought is at this point, if you need an order to instate because it's outside the period and you've not had an event such as the divorce, which the judgment would allow you to apply, check with your healthcare provider. And I would suggest that, yeah, you get the right to, you know, try and apply for that. But I would say that that's going to be the easiest way here. And if you need an order, Mr. Van den Hubel, for your client, I'd be more than happy to sign that order to say that she's got to get her own insurance. But at this point in time, due to the events that have occurred, I don't think I have a choice. I'm not going to order him to carry you on insurance because that's only going to last, hopefully, 2 months, maybe less. Let's get this done. And as to attorney fees, there's no way I'm granting attorney fees on this. And so I'm deleting your motion to strike, Mr. Van den Heuvel, those pleadings, because I'm going to rule on them, and therefore I'm not granting. I mean, the parties have done, and I'm not sure what the heck happened. Again, Ms. Ballas, sounds like you've got some legal work that you can go with the employer, because I think it's kind of a problem for an employer to fire somebody over a court order, if that is in fact what occurred. It's also not within the constraints of the law for that employer to delete health insurance at a whim.
Understood.
So, but what else can I do for you? What else do you need? Do you need a
Referee-
settlement conference or something to get this moving, to get this done?
We would
We
after
have-
our mediation, but can I
Okay.
ask for an order then for her? Because
Yeah, I said I'm going to grant her an order that says that she needs to get her own health insurance, because that may be an okay event to trigger her to get her own. And that would be the better solution here and the cheaper solution, because you don't want to switch this in 2 months anyway. And then getting him to get her the insurance. Now, any costs or something might be arguable in a mediation or a divorce trial, but I'm not sure if there were no costs incurred. There's no monetary damages done. Now, if she was ill and absolutely needed some medical attention, we would talk about those medical bills, because they're still marital. You guys are still married, therefore the bills are going to be marital or arguably marital. So, and it could be argued, the reason that I asked the question about how much you incurred, Ms. Connolly, is because under these circumstances, sir, you may have been charged 100% of those costs, because it was events that happened under your purview that necessitated the cost. But since there are none, we don't even have that discussion. I'm just trying to put you both on a path that can get you through this and get you divorced. You said you have
Do I
mediation
need to
scheduled?
wait?
Yes, mediation is scheduled for May 21st.
Okay, what, Ms. Conley?
I'm sorry. Do I need to wait still another however long this takes?
That's why I'm issuing an
for it to
order.
be?
I'm issuing an order. That way you have something to take
Okay.
to your health, to take to your human resources, to say, look, I've got a court order that says I have to carry my own insurance now.
Correct. As far as seeing a doctor that I've been waiting.
You may have to wait until you get the insurance, but you're going to have to wait one way or the other. Even if I had him do your insurance, he can't get it for another month, because that's when his employment would allow for it. We only cover people through the employer if it's available at a reasonable cost.
Correct.
So,
he canceled the insurance back on May 31st. It was 1 month after he left.
well, and again, I was, he's saying his employer did that. I'm saying that smacks of some problems.
Yeah, I spoke
And
with the insurance company.
yeah,
Told me
so
the
I
whole
don't
story.
know how it was done. I know that I've got arguments both for and how it was not, and they contradict each other in your pleadings. So I would need to have a hearing and probably hear from the insurance company as to who, but you're going to spend a lot of money to get nothing out of it. Okay. So
Okay.
that's why I'm trying to lead you down this path that will set you to finalizing this.
Thank
Because
you.
right now I can't undo what was done months ago.
Correct.
Well, I could if he was still at the employer, I could order that employer, but he already had the order to reinstate. He was ordered to reinstate it then and he got fired. So again, those are other issues not before the court because you two are the ones that are on this case, not any third parties. So, all right, Mr. Van Heuvel, I'm granting you the order. I'm not granting any attorney fees on this. And if you need a settlement conference after the mediation, please contact my clerk
I will.
Will do.
Thank you.
or contact judge's clerk if you prefer him. No problem. All right.
Thank you.
You know me. I don't have a choice as to what I hear. Judge gets to choose that, but let's get her insured.
Agreed.
As right now, neither one of them are insured, so they're both out in the wind. And then he'll get his insurance when his employer allows for it at the end of May. Good luck, everybody.
Thank
Thank
you.
you.
Honor.
Take care. The pleadings in that one were messy. But like I said, what do you mean technically they're not married? Excuse me? What?
Okay.
Next.
I finally got the prison here for
Okay.
Zarnecki Thompson versus Thompson. It's a 2010 case.
Yeah, I got it. I've now broke the piles into 4 piles. So, Mr. Thompson, can you hear us?
Yes, sir.
Okay. Do we have Tanya here?
No. Ms. Zarnicki is incarcerated.
Right. Tanya is incarcerated?
Yes, she is.
Okay, I don't think I have the right prisoner here.
Yes, you do.
Oh, that's Tanya?
Yep.
Okay. Alrighty, in that case, let's go on the record in the matter of Zarnacki versus Thompson, case number 1. Okay, I guess my question is this. We've got a motion for support, and Ray, that's by you. Where is the child at?
Charles, he's incarcerated now as well.
Okay.
Let me.
Well, and is there a guardianship involved in this too?
Yes, that's what I was going to say. Let me try to explain this.
Yeah, please.
My son was, well, our son, should I say, was placed in guardianship with his grandmother, Andrew Miller Dewey.
Okay. Okay. And that's through Kent County.
No, he's in Genesee County. I believe.
He's in Genesee County. Okay, I was wondering. Okay.
He got himself mixed up in a little trouble.
Right.
And he's paying the consequences for it right now.
Okay.
But at one point in time, he was placed in my home. And while he was here, I made sure he had absolutely everything he needed. He then took and wanted to go spend a weekend with his grandmother.
Okay.
And he ended up taking her car.
Okay. All right. Well, bottom line, is there a guardianship still in place in Genesee County?
Yes, it is.
Okay. Now, the other question I have, obviously, Tanya, you can't pay support because you're incarcerated. Ray, I have control over the support, but I have no control over parenting time. The guardianship controls that. Custody and parenting time are now through the guardianship. I can get you the child support reviewed, but that's going to be dependent upon your income. Okay, because under a guardianship case, it's considered a third party case, and they don't consider the third party's income. It's based all solely on your income.
Okay, because right now I'm only working 2 days a week.
Okay. Well, that's why I was going to ask, because at this point in time, it's set at $129.
Right, and I cannot afford this, sir, at all. son is incarcerated. So
I understand. Well, a lot of times what will happen is the state will confiscate parts of the child support then to help pay for the incarceration.
okay.
So I will send it for child support review. That's the best I can do. I can't do anything about parenting time though.
Okay.
That's and if your son's incarcerated, he's in the juvenile detention, correct?
Yes, sir.
Yeah. The any parenting time or visitation or stuff like that will be controlled now by the probation department.
Okay.
So they will. It's good. They will override the guardianship
Okay.
while he's a court warrant under probation.
Okay.
Okay. So you'll have to work through the probation department and the guardianship as well
Okay.
with the guardian. You know, how old is this child?
He'll be
15.
yeah.
Okay.
He'll be
15?
he'll be
Okay. All right. So I will send it for support review. Is there anything else you need?
No, I have another case.
Yeah, you do. Okay. Yeah, my clerk brought that up. Tanya, is there anything you'd like to add?
Just like to correct the fact that he's in Ottawa County, not Genesee County.
Oh,
Thank
yeah.
you. And that's where the guardianship is?
Yes.
Yes, sir.
Okay, cool. All right, then that's who you have to go through, and then you'll have to go through their juvenile. You'll have to contact his probation officer.
Okay.
The probation officer should be contacting both of you.
I
I'm
don't
assuming.
get any
Yeah, when I do review hearings with juveniles, we bring in incarcerated parents all the time. We also make sure that the parents are there. I need somebody with legal authority and the guardian, because the guardian has the legal authority over the child at this point. Okay.
I'm in the process of trying to remove that guardianship.
And that's why everything like custody and parenting time goes through the guardianship, because this court loses jurisdiction during the time period of a guardianship.
Right.
Probate court has jurisdiction over the child. I can still play with child support because normally the guardianship orders it or says no. They can also say, the support, they can also set support, but they generally send it to our court to have it sent through the front of the court for the child support.
That makes sense.
Okay.
Yeah. And some of it doesn't. Most of my cases this morning have like zigged and zagged. So your pleadings, I was kind of like, I got the gist there may be a guardianship, because I was like, okay, I'm reading it and I'm like reading between the lines a little bit on what you asked for. So, all right. So Ray, we'll get you the child support review. Tanya, is there anything else you need?
No, sir. Thank you.
Okay. Good luck with the working on that guardianship, and Mr. Thompson, stick around. I think the other case is with someone other than Tanya, correct?
Yes, it is.
Alrighty.
The other one was with Shannon Burgess.
Okay. Got to find that case. Sorry, I've got stacks of files here. So
yeah, because the situation was I was trying to get the state to take the payments down some, because like again, I only work 2 days a week and I get paid every 2 weeks.
I understand what the situation is.
And it's hard.
You just always have to be careful with your request on child support.
Absolutely.
Because once you ask for it to be reviewed, it can go up, it can go down.
Okay. That makes sense.
Well, it's set by law, so that's why I always hold my breath whenever anybody asks for it. Okay. And Ms. Burgess, welcome. I'm just trying to find the correct file.
Oh, you're fine.
See, this is the bad part of when I'm not in an actual courtroom where my clerk handles all the files. Right? Why am I not finding your file? There it is. Okay. Now that I have the file, we're here in the matter of Burgess versus Thompson case. Okay. Again, I believe this motion is yours, sir.
Yes, sir.
What do you have to add to it?
Just simply like the payments are too high. Besides that, I don't get the chance to see my child at all.
Okay.
The stipulations was that if I wanted to spend time with him, I have to come to her house to see him, and that shouldn't be the case.
Well, at this point in time, child support, parenting time is by agreement. So she kind of has control of it at that point from the way this court order reads. Ma'am, what do you have to add to this? What's your
First
input?
off, first off, the reason I said that he has to come to me is because my son, after the last time he had seen him, my son had came with disabilities. And so I was telling him he had to come to me so
Okay.
that way he can learn how to deal with him. And since then, a lot of things have progressed. But I don't agree with the child support being changed because
Well,
there's a lot of things that go with that.
Well,
I understand that he has the right to have it reviewed because the order
I
is over 3
understand it.
years old. So it's not that I'm going to change it, but it may change, it may go up, it may go down. But he also has the right to ask for specific parenting time. So, and in consideration of the disability, that would be taken into effect. So what I would do is, what I would do is I would send this to the front of the court for parenting time and child support. The fees have been waived by the judge in this case. So they will talk to both of you. That way, Miss Burgess, your concerns can be addressed over your child, and sir, your concerns, because the child has the right to know both of you. We just have to do it safely. And, if the child has certain disabilities that you need to learn how to take care of when you have the child, then you need to be trained. So that's a legitimate concern. So we'll see how that works out. But the front of the court will sit down with both of you and, do what I can't in 5 to 10 minutes on a Friday morning, because they will spend hours with you and they'll review, your work schedules, the child's schedule, the child's disabilities or needs or special needs, and figure out how to do this that both of you see the child and the child sees both of you.
Absolutely.
All right. Any other questions?
That's all I'm asking.
Okay, and that's that you have the right to ask for that. Ma'am, do you have any more questions? And I understand your concern.
No, I'm just gonna keep quiet.
No, that's okay. The child has the right to know both of you, so we'll see what we can do about having that happen. It's got to be done safely.
I'm sorry, he was never denied. He was offered for
Well, you just kind of explained that you had some concerns because of the disabilities of the child. So, and again, the court order at this stage was set so that it was by agreement, and that's the way it was. So now that there's some problems and some disagreements, we need to step in and get a proper, specific parenting time order. Okay.
Through the courts, I think is the best.
Yeah, and we'll see. All right. Good luck.
All right.
Take care. They'll be contacting you soon.
All right. Thank you.
Take care. All right. Next. Okay. Good morning. Ms. Garcia, did you connect? And we know Mr. Peltier connected, so.
Hello.
Good morning. Welcome.
Welcome.
All righty. We are here in the matter of Garcia versus Peltier. So I've read your motion, ma'am. Is there anything you'd like to add to it?
No, I was just requesting for full physical legal custody just due to the things that I put in the motion.
Right.
And I'm not too worried. Like, there is a open child support case.
Right.
And Mr. Pelletier has collected my son's per cap over the last 7 years. I did talk to somebody.
How has he done that?
They said he goes and picks up the checks. I did reach out to the tribal center.
I assume the tribal center, the per cap, which tribe?
Odawa, I'm sorry. Little Traverse Bay Band.
Okay. And you have alerted them because if I remember correctly, that who is the person with Indian heritage, he or you?
My son.
Which parent?
Oh, his father. Yep. Okay. And so, yeah. And so I reached out to them because I never got any more checks sent in the mail. And they said that.
Do you know if that was used as part of his income?
They don't use that as part of his income. They can only garnish. They can only garnish the ones that are on the record. And I already talked to somebody at FOC.
All right. So you have contacted the tribe and FOC concerning that matter.
Yes, but the lady at the tribal office had advised me that there had been additional funds released that are not set as automatic payments that have been collected, but she couldn't give me any other information because I'm not a tribal member.
Right. I was going to say the tribe controls.
Yeah, yep, yeah,
yeah,
yep. So
yeah.
she said I would have to have,
Because I can't order the tribe to do anything either.
yeah, no, and that's why I filed this motion is because she said I would
Right.
have to have this paperwork to go
Right.
in there to make sure that he doesn't collect any more funds. And then at that time, I
Well,
can unenroll
okay.
my son.
All right. Well, I have some questions. Ms. Peltier, what is your input? I didn't get a response from you, sir.
Oh, excuse me, I was just listening. That, there really not much to say.
Okay. Well,
I was just wondering
yeah,
about the emotion about, just a whole lot of mess going on in that. Like just all of a sudden she just ups and puts this motion in, and I have not contacted her, have not, done anything because anytime I do, she does say I'm harassing her, so I quit talking to her. So
okay.
I don't.
Well,
So
this case is about 9 years old, so I don't think she just up and did it. I think she did it because she needs an order that says certain things to
That's
acquire
correct.
certain benefits. That's the only reason we're here.
Yes, I don't receive.
And what she doesn't understand, and what I'm about to explain to both of you is, ma'am, you do have sole legal custody and sole physical custody already. You just need an order that more specifically says that.
Yes, that is correct.
Yeah, because you have sole legal by statute, you have
Yes.
sole physical by court order.
Yes.
So you have what you're asking for already.
Yes,
That's
and
why,
so
that's why I was wondering
well,
what his input is, and parenting time is set by agreement.
yes, and there hasn't been anything set standard over the years
No, like I
because
said, this is a
yeah,
9-year-old case, and there's nothing that's happened since it was first filed. So this was filed by the prosecutor's office for the state through the state of Michigan because state aid was involved.
yes, yeah,
So they
at
brought
that
the
time.
case. Neither one of you did.
Yeah,
So
yeah, and the only reason why I'm filing for this is because I need something physical because in the original order it just says that I have physical,
custody.
but yeah, I
Right.
just have custody, but I need something
Again,
stating
the prosecutors are only allowed to deal with child support. That's what they're here for.
yes,
They have to label who gets custody because the federal law requires the custodial parent gets the benefits.
yes,
Therefore, that's why that's in there.
yeah,
They do not deal with legal custody.
yeah,
But a child born out of wedlock in the state of Michigan, the legal parent is the mother and or the mother and the father if an affidavit is signed of parentage, or if the court orders it or the parties get married. And the affidavit actually, sir, Mr. Peltier, when you signed the affidavit, you gave her presumptive sole legal and sole physical custody when you signed it.
okay.
So generally what I'm doing at this point is just explaining things, but I'll grant her a more specific order so that she can work for the benefits that she's looking for. The other question I had was, yeah, are we, yeah, the review, child support has not been reviewed in a long time. Did you guys want it reviewed or just let sleeping dogs lie?
Well, no, I would like it to be reviewed.
Because of the underlying Indian income.
Yeah, and not only that, the income really, I mean,
I don't see that that's mentioned anywhere in these things.
yeah, because they only issue a per cap check around Christmas time. However, in the recent few years, well, the last year, they have been dispersing other amounts that are not set as a regular per cap. And
Again,
he's been,
and
yeah.
that is their
Yeah, that's their right. No, and I understand that, but that's the real reason why I'm asking to have more documentation, clarified.
And that's what I'm granting. I'm granting you a clarifying order to say that you definitively have sole legal and sole physical custody. You have had for 10 years now. And then I'll send it to the front of the court for a child support review. Because of the way your request was worded, I didn't know whether you wanted the child support reviewed or you just needed the order to deal with the other issues.
I mean, the child support is so far behind. If they want to review it, they can. I'm not.
Well,
I mean,
at this point, yeah, I'll just go ahead and have it reviewed with the underlying Indian income. Mr. Peltier, do you have any questions, sir? You've been pretty quiet.
Oh yes, I was just listening in.
Okay.
I'm actually I've been talking with a lawyer from my tribe. I'm going to get the case moved up to my tribe, so so she'll be handing some paperwork in. So.
Okay. I don't know if this court will relinquish jurisdiction at this point because the case is 10 years old.
Oh
yeah,
no,
I was already.
Yeah.
I talked to a tribal lawyer that would represent my son, and she's the one that advised me to do this because there hasn't been anything set in play.
Okay.
And that this is the best way to go.
All right. Well, your motion's granted, and good luck with all the other subsequent actions that are now going to occur.
All right.
All right.
Thank you so much.
Take care. Have a good morning.
You as
Thank you for your
well.
time. You have a wonderful day. Yep,
You
bye.
too. Good luck.
Yep, thank you.
Okay.
Okay.
Next. Well, do we have the other side here yet?
Not yet.
Okay, ma'am, we're going to relabel you from your phone
okay.
number to your name, and we'll bring you in when we have both sides present. What was your statement? Well, what were you going to say? I'm sorry, I didn't mean to interrupt.
That's okay. I was just having issues with my computer, so I wanted to make
Okay.
sure the phone call's okay. Otherwise, my computer
It's fine.
did restart, so I couldn't get on.
It's fine.
Okay.
Or you can try the computer if you wish to, whichever's easiest for you.
Okay.
All righty?
Okay, I appreciate
We'll
that.
see you again soon. All right.
Okay, let's do Jennison versus Fountain. I just have defendant here, moving party.
Okay. Mr. Fountain, welcome, sir. Did you connect? Can you unmute, please?
There, yes, I'm unmuted.
Okay, welcome, sir. We are here in the matter of Jennison versus Fountain case number. Mr. Fountain, this is your motion. I will note that Ms. Jennison did not appear. This matter was set for a hearing at 8:30. It's now 9:27. So it looks like mostly you're not asking for custody, you're asking for parenting time, correct?
Yeah, honestly, that's all I would like.
Yeah, okay.
You know, and she did. I didn't want to make a problem for her either. Okay, so I want you to know that.
Well, it's okay. You have the right to ask for parenting time, sir. Relax. You don't have to apologize for that.
Well, yeah, I just didn't want to get her in trouble, or because then it causes problems for my
There's no,
baby. And I
there's no,
don't want.
yeah, nobody's in trouble. What it is, the court orders right now, the parenting time is by agreement. And if you don't agree, then you have the right to ask for a specific time. So that's what we're going to do. We're going to send this to the front of the court. The judge waived the fees on this case, so I'm going to send it to the front of the court for a parenting time review. That way you get specific time. Okay. When was the last time you saw the child?
About a month ago.
Okay. So you do have contact and the child knows who you are.
Oh yeah, the baby loved the dad.
Yeah.
Yes,
Well,
this is my little girl. Yeah.
Babies love both parents. So what the law says is that the baby has the right to know both the parents. We just need to do so in a method that's safe and continuous.
I'm sorry, sir.
Oh, that's okay. We need to do it in a manner that's safe and continuous and consistent.
Yes, please.
So yeah. All righty. So what they're going to need from you is to make sure you have
what
your
do
work.
I do now?
The front of the court will be contacting you. I can't undo in 5 minutes what you guys have been doing for years. So, I don't know your work schedule. I don't know when you're available. I don't know when she's available. I don't know when the child's available. As I just had in an earlier case, and it came up in the motion that the child has disabilities. I'm like, that's interesting because the file doesn't say anything like that. But there are those kind of things that occur that I don't know about, so I don't issue strict orders on a Friday morning. So rarely I can. There's sometimes people give me enough information and we work through it. But on these facts, I've got to send it to the front of the court. There's normally a $300 fee. Don't worry about that. You won't have to pay it because the judge has already waived your fees. So I will send it to the front of the court for a parenting time review. So, all right.
Okay,
that way you
great.
get
And then I'll just wait by the mail and.
Yeah.
Okay, thank you.
No problem. Good luck.
Thank you very much.
You take care and check your email. They may email you as well. Okay.
Yes, sir.
And they will also make sure that the mother gets involved. With them, they're not going to take kindly if she ignores it. So, okay.
Yes, and I didn't want him to have any problems.
No problem. This is not a problem request. You guys have a child together. You have the right to see the child, and the child has the right to see you. So we'll get that moving along. All right. Take care of yourself. Good luck.
You too, sir. Yep. Bye-bye.
Good morning. All right. Next,
we can do Ford versus Bynum.
I would think that the piles are down enough that I could find a file easy, but I can't. All right. Oh. Morning, everybody.
Good morning.
Morning. Okay, so everybody's connected. The only person that we need to check on is Miss Ford. Did you finally connect, ma'am?
Yes, I'm here.
All right, wonderful. All right, we are here in the matter of Ford versus Bynum. Mr. Arnson, I believe this is you. I'm sorry, Ms. Van Dyken, is this your motion?
It is, Your Honor.
Okay, sorry.
Okay.
There's way too many pleadings in this case. I just realized why I'm looking weird at it. I have somebody else's pleadings in your case. That's why I'm like, there's twice as much here as there should be. Come on.
We're not getting paid for that. That's the one thing Jeff and I could agree upon.
Yeah. All righty, folks. Ms. Van Dyken, what do you care to add to your motion?
Your Honor, this, as short-lived as this case, it almost has a long toward history.
Right.
Parties just don't get along. There were previously dueling PPOs against one another, which were set aside for a civil restraining order. That's just not working. My client gets bum rushed at exchanges by Mr. Bynum's mother. He always brings his parents, and it's inefficient, and it's for my client's safety. She wishes to go to Safe Connections, and that way the parties don't have contact. Safe Connections, they don't need their third-party people, support people. They could just do the Safe Connections. And we don't need to go and file for more PPOs or anything. I think this will add another layer of safety. And we can, that's all we're asking for, Your Honor.
Yeah. Mr. Aronson, I've read your response. What do you have to add? Because my question is, I have a feeling the fire department doesn't want you people there anymore. So, I mean, I'm going to have to do something.
Well,
I mean, I don't want to tick off the firemen or the fire individuals, fire people.
I understand that, Your Honor. The problem here is that there were no issues for the last several months. If you go back to the issues between at the pickup and drop off, where it was kind of a tense situation because the minor child was not always going to the mother. But for the last several months, there's been no issues. The parties stand there. Nobody says anything. The minor child walks from one parent to the other. Fast forward to April 4th, all of a sudden, the defendant or the plaintiff here starts demanding they go inside and starts bringing her boyfriend to the pickups and drop-offs. So that created the issue here. So she's claiming that there's a safety issue, but she's the one that created all the drama and all the problems.
Well, I could tell them that nobody gets to go but them. That would be one solution. But
the fire department and the police department are
like I said,
standbys.
like I said, I'm going to have to deal with the fact that the fire department probably, for whoever did this, whatever, they're going to have to, I'm going to have to move it to somewhere. So I was going to suggest a police department, but that doesn't sound like it would be a good idea either. So I think Safe Connections is the way to do this, and then we will review it in 6 months, and hopefully it won't be necessary then. But then I don't have to limit whoever goes with them either, because otherwise I'm limiting who's going to be at those exchanges.
Your Honor, I guess I would probably prefer the police department. I think my client would, just because.
Well, I don't think that I'm going to be able to do that. If there's a problem at the fire station, there's going to be a problem at the police station. I'd rather Safe Connections divides them. One comes in one door, one goes out the other door. And like I said, we'll review it in 6 months.
Well, yeah, Your Honor, we're probably going to have an evidentiary hearing before then, but.
Yeah. Well, then we'll review it at the trial. I have no problem with that either. But yeah, I can't have fire department involved, and then in 2 months we have another. And again, I don't know who's causing the problem. According to the pleadings, it sounds like third parties, not the actual parties themselves. It sounds like third parties are causing the problems. And yeah, I would delete those parties from being there, but Safe Connections means that I don't have to. They can take a whole posse if they want, because nobody's going to see anybody. One goes in one side of the building, one goes in the other side of the building. The parties are never going to see each other. The exchange is done within. And that's a temporary solution. I expect the parties to grow the heck up and be older than their own child and be adults in this situation and eventually do these exchanges correctly and at their own homes.
Your Honor, I understand the court's ruling, but
Then quit arguing. The court has
No. Go ahead, Mr. Aronson.
Just to state for my client, he's not the one causing the ruling.
I'm going to let him put a statement on. He's not arguing. He knows what the court's ruling is, and that's going to be my ruling. Mr. Aronson, what did you...
I understand the court's ruling, but my client is not the one causing these issues. So
again, the pleadings go both ways. And like I said, according to the pleadings, it sounds like third parties are doing this, not the parties themselves. And I agree, this is going to stop any personal protection orders from having to be issued. That will also be a problem, because then we get a personal protection order war between the parents, the boyfriends, the girlfriends, the significant others. And then I get the wars when the case becomes the grandparents' case. No, thank you. Let's separate them for a while. And the two of them can remain civil. And if we have to deal with third parties, I will do so at a future time. All right. Good luck to you. But that'll be the court's ruling at this time. All right. Thank you. Thank you. Next.
Medina versus Doc.
That one was on top. Hey,
Oh, wonderful.
easy to find.
Okay.
All right, ma'am, did you connect?
Yes. Can you hear me?
Yeah, I heard Mr. Doc's voice, so I know he connected. So that was pretty
Okay.
obvious. All right, so we're here in the matter of Medina versus Doc, case number 1. I guess, is Child Protective Services still involved?
Yes.
No, sir. They got closed yesterday.
Okay. Did they close it to your knowledge? They don't close it to
Yes.
your knowledge, Miss Medina. You don't have knowledge that they closed it?
Nope. No.
All right.
They told her.
Well, I won't ask if the sky is blue because I'll get a different answer from each of you. All righty. What was the underlying issue of the CPS case, Miss Medina? This is your motion, so I'll ask you that question.
Okay. So CPS was contacted due to Daniel abusing Brenda in front of the children.
So
So
it was a fight between his current significant other and him.
yes, Miliana described that Daniel dragged Brenda from the room to outside.
And therefore
was
the
abusing.
children were present for the alleged event.
Yes, they were. And they said it happened multiple times.
Okay, Mr. Doc, are there any police charges or?
No, sir, that's a lie. And she talked to CPS herself. So this is all lies. Made up allegations on her end because she's mad because she wants to take my kids because she gave me half custody because I earned it. I deserve full custody, honestly, because my kids have been neglected to learn. They're getting held back because of her don't want to be in the state on time.
You know, I've got allegations enough in the pleadings to send this to the front of the court.
We'll do what we got to do, sir.
For custody, parenting time, and child support issues.
Yes, I also.
All of them are up for. At this point in time, I will tell you, Mr. Doc, that according to the previous court order, she has sole legal and sole physical custody now. Parenting time is a separate issue. But it's my understanding you guys came to some agreements, but there are no agreements any longer. And I don't have a court order really listing what those agreements are. So I will send it to the front of the court to get a proposed court order to solidify what the arrangement should be.
Okay. I have a question. Were you able to get my video as well?
Yeah, I was trying to figure out what the heck that was. I was able to play it, but it didn't seem to make any sense.
Well, that's another thing too. So my children have been witnessing Daniel selling drugs as well.
Okay,
so
yeah, but
that's
all it
another
was
thing.
somebody sitting in a car giving me a diatribe, and I'm not sure that
Yeah, so it was.
that's not really evidence of anything. I mean, it was. I'm kind of like, okay, but not helpful.
Okay.
So, all right, but I will send it to the front of the court for custody, parenting time, and child support. Okay.
Okay, thank you. So when do you think we'll be getting a court date for that? So I can
They
also
should be
send in the other
contacting.
video.
They should be contacting you in the next couple of weeks to set up an appointment to meet with both of you. And yeah, they can look at a lot of that stuff. So the court doesn't necessarily get to look at that stuff. It's got to be entered appropriately, which is why the only reason that I even attempted to watch what you did was because I wanted to see what the heck it was. But it's nothing to the court at this point. It's not evidence. It's not anything. It's nothing. Evidence comes to the court through a witness in the witness stand.
Okay.
So you don't just, what you just handed the court is an offer of evidence, basically. This is what I think I have as backup. Now, the front of the court can look at that stuff and make determinations based on it. Sir, you'll be able to do the same things.
Okay.
You'll be able to show, and, maybe they want to talk to each of your significant others.
Oh, that's perfect.
But you can ask them to. So,
Sure.
and they have the right to contact CPS as well. CPS is supposed to cooperate with the front of the court to ensure that orders are issued properly for the protection of the children, if necessary. And if it's closed, it's closed. But that's still pertinent information, Mr. Doc. And the pertinent information may be that they don't find anything wrong.
They're not going to find anything
well,
wrong.
and that's what I mean. I mean, it could help you or hurt you. I don't know what the facts are.
It's gonna help me, sir. And at the same time, we haven't been together, and she's been falsifying.
This case is 7 years old. So yeah, you haven't been together
Right.
for a while.
No,
So
hold
we're
on,
gonna
hold on.
work.
We
Yep.
haven't been together since July. Let's put that on wax right now. Since July.
You guys got back together after the case started?
Since July, we have not been together of 2024.
He took me to court for the
We've been
kids
together
in
since
All right,
February.
guys.
all
Yeah, all right.
since my kids were younger. We've been together since birth.
All right,
And
because
just until July, we haven't been together. So
okay,
whatever she
yeah,
put
I'm
down
sorry.
on
It's
paper
the
is
case.
lies.
Well, the case is a 2018 case.
Okay.
I didn't know you guys got back together. That's not in the case.
Yeah, we've been together the whole
Okay.
time, sir.
All right.
He's
Well,
been
and
lying
that's
on
why
paper.
that's why it's again there's nothing on
Right.
paper. The only paper is the fact that they entered a child support order. You guys didn't bring this case. The prosecutor did because of state aid being involved.
Okay, what she put in writing, if you look at it, it doesn't make
I looked
sense.
at it. That's why I said, and I'm trying to get both of you through this because you don't have any orders in the court file to say who has what. So
Okay.
parenting time is necessary, and so
Exactly.
yeah. All right. So let's get you through this. I can't again undo what you guys have been doing for years.
So just to clarify, I have sole custody, right, of the children?
On paper, yes. But if
On
you guys have been
paper.
living together, the custodial environment is who the children
No, we
look to.
haven't. Oh,
We
so they
have.
go with me.
We have been living together, sir.
They've been with
He's
Guys,
me.
lying.
Well, I'm
because
trying to talk, but he doesn't let me. That's
I
what I'm
was too,
confused.
but you won't let me either. So I'll send it to the front of the court. Have a good morning.
Thank you.
Have a good day.
I was going to explain to them custodial environment happens, regardless of a court order. But oh well. All right, next.
Studebaker versus Studebaker.
Okay. Mr. Studebaker, did you connect?
I did. Can you hear me?
Okay, yeah. Ms. Katzman, did you connect?
Yes, I'm here.
Okay, wonderful. Welcome. We are here in the matter of Katzman versus Studebaker. Sir, this is your motion. What do you have to add to it?
Yes, I'd like to start with can we start with the tuition motion?
Okay. What
There's
about the
two.
tuition?
Well, I'm just going to read what I wrote. Your Honor, paragraph 5 of the divorce judgment requires the plaintiff and myself to equally share the tuition costs.
Right.
For our sons at Tri-Unity, 50-50.
Right.
To date, there has not been transparency regarding these payments aside from the letter the plaintiff submitted.
How is there the transparencies from the school? Is the school not communicating with you what the bills are?
I'll answer that question right here. So on October 3rd last year, I requested billing transparency from the plaintiff. She responded that she does not handle billing and directed me to contact the school. See Exhibit A. When I contacted the school, they informed me the plaintiff had instructed them not to release any tuition payment records to me. See Exhibit F.
If you're paying it, you get it. You get copies of the bills. That's all there is to it.
Okay, well, so my request, then I'll just skip to my request, is that to ensure transparency, avoid future disputes, and reduce the need for further court involvement, I respectfully request the court to issue an order stating the Christian school may release full tuition billing and payment records to both parents on an annual basis with any financial aid information for either party being redacted. I'm not getting financial aid. The plaintiff has expressed that as a confidentiality issue. I stated in writing to her and the school, they can redact all that if they want.
Well, bottom line, I think your court order says that you guys will pay 50-50, correct?
Correct.
50-50 means 50% of what is actually paid.
I do agree. I was trying to be gracious, but it's been a battle for 6 months.
Yeah. Ma'am, what's going on?
Yeah, so the school's policy is to split the total tuition, which is like $7,420.
So you're talking about $3,700 each, correct?
Correct.
So you actually pay $3,700 and he pays $3,700.
No.
I'm asking the question on purpose. Okay. So you actually pay $3,700 or is your bill reduced?
So both of our bills are reduced because my mom works there and we get a 50%
so both of your
discount.
bills are both of your bills are reduced.
Yes.
All right. That's what I was trying to get to. Okay. You know, because if that's the case, I am going to issue an order saying that trying is to give him copies of the bills. He's allowed, if he's paying a bill, he gets to have a copy of it.
He does. So our billing is like split there. They basically take both of the boys' tuition. Because we're divorced, they can pay our bills like separately, essentially. We both have like an account through their system that deducts that amount from our accounts every month or whatever.
You're concerned because you don't believe you're paying 50%. You believe you're paying more than 50% because she's paying less. And you just want confirmation of that, correct?
Correct. I think the school has worked it out now, but because this has been a battle for 6 months, I'd like confirmation now and going forward so we don't have to come back to court.
All right. So if I take both of your statements as it is, it sounds like there's a reduction here because one of the parents, one of the relatives of the child goes to the works at the school, and that's great. And then both of you should receive proportionally that correct deduction. Again, 50% of what's actually owed is what should be paid. So yeah, they should be giving him copies of all the bills and what's owed on the children. Next.
Thank you. So we're done with that one then?
I guess I'm issuing the order. I'm going to issue an order that says that is to openly give you copies of all bills.
Thank you. So the next
I guess my question with that.
Yeah.
So just to be clear, I don't know how that helps anything from what Andrew's stating. He's asking for my
I'm asking him for any. Well, I think that's legitimately requested. You're telling me you pay $3,700. He'd just like to confirm it that you each are paying the equivalent amounts. Because if you're not, he has a whole nother matter here.
Correct, and I understand that. I think for me, my concern comes down to the fact that the school has put it in writing that that's the case. I have told him that's the case. And we're in court over that. It seems.
And the court is issuing an order saying you will divulge the underlying documents that show it.
Okay.
Again, I'm taking you at your word. For now. He has the right to review that and make sure that what you're saying and what they've said is the truth. When you start to hide stuff, that's when people start to question more. Just telling somebody something or sending them a statement going, we do it, is not enough. Background documents are also something that should have been stated. Okay? Like I said, if he's going to be ordered to pay a bill, he gets copies of what the bill is and the necessary documents to show that it's an appropriate amount. Because again, it should, hopefully from what you're saying, it should show that each of you are paying equally. If it does not, he has a whole nother matter here, and he has the right to make that request. Okay? You know, if he were an attorney, what he'd probably do is just issue a subpoena for all the records from the school. And the court would have signed that. All right, next issue. Next issue, sir.
Sorry, I was taking a note. This is regarding Our Family Wizard and communication, Your Honor.
Yeah.
I respectfully request an addendum to the December 2021 order regarding Our Family Wizard or a separate order as the court deems appropriate, as outlined in the motion. This request is intended to promote open communication.
Yeah, I can't do that. I can't order third parties to be involved in My Family Wizard. That's between the two of you. You're asking for the student, for the all professionals involved?
I'm asking for the opposite, Your Honor.
Okay.
The plaintiff is trying to force, has told the boys' counselor, the school, and doctors that they cannot communicate with us in any manner on the same platform. She's tried to force them to go to Our Family Wizard.
No, they cannot. No one can force them to go to Our Family Wizard. You have the right by law and by court order to talk with any professional involved with the children, any school personnel, any medical treatment, any dental treatment. Both parties have the right to contact those people and talk with them. No one has the right to stop that. You are both legal parents of this child or children, and therefore you both have the right to do that.
Your Honor, what the plaintiff has told them is, we'll take one example, Du Bois's counselor. She has told the counselor over and over and over that the counselor may not communicate with us jointly on an email.
That's not accurate.
That's
I told the
that's what
counselor
I was
that-
going to. That's what I was going to ask. The counselor has the right to choose who they email and
Correct.
how they email. So if the counselor wants to put
Correct.
both of you on an email, they can. If the counselor has an issue with one of you over another, they have the right to contact the other person. The counselor
Correct.
controls that. So, but it's
So-
not through My Family Wizard.
Your Honor, what I am asking for is an order or a letter that I can take to these professionals, because they've been told, in my exhibits, I give, there's multiple letters in there from the counselor where she has requested even something as simple as